So good morning, everyone, and welcome back to our weekly webinar series. Today is our 103rd episode, and we are looking at a very interesting topic, which is called on willful defaulters. So this process is an old process, and it has gone through many changes due to various judgments, due to the changes done by RBI and the entire framework on who can be held to be willful defaulter. Over to Anil, sir.
Thank you, Ankit. Welcoming all participants. A very important subject triggered by a very recent judgment from Bombay High Court that was on 4th March 2024 in the case of Milind Patel versus the Union Bank of India. So then we started studying and researching on this subject. In fact, earlier also long back, that was not part of this weekly webinar series, but we actually conducted a webinar on the fraud reporting by the bank. So therefore, today we would be discussing what is the circular of RBI on willful defaults and how to report, what are the obligations on the banks to report willful defaults. And also with a little bit of comparison between the directions issued by RBI on fraud reporting and reporting to the investigating agencies. So this is because there are two important judgments of Honorable Supreme Court, and one of the judgment which is in the case of 𝐝𝐬𝐬𝐜𝐿. So that is also something which triggered RBI to bring a kind of directions on fraud, and those directions were brought in September 2023, but has not been implemented because those directions were taken basically to seek the public opinion. So I think we actually can continue, Ankit, our subject. So we actually, first of all, we would be discussing the Master Circular, which is dated 1st July 2015 on willful defaulters. So basically, when this Master Circular came, it consolidated all instructions on all the scheduled commercial banks and notified financial institutions how to deal with willful defaulters. And the basic purpose was to put a system on place to disseminate the credit information pertaining to willful defaulters, so that basically all other banks should be cautioned, financial institutions are cautioned, and also kind of public is cautioned, so that the SEBI also is actually relying on this list of willful defaulters. And also the insolvency law also relies on this willful defaulters for eligibility of a resolution applicant under section 29A of the IBC, and also whether the further bank finance would be available to willful defaulters or not. Then we also have master directions on frauds by Reserve Bank of India. That is also incidentally 1st July, but that is 1st July is 2016, whereas the 1st July 2015 is the circular on the willful defaults, whereas the master directions on frauds is 1st July 2016, and of course it was updated next year on 3rd July 2017. And in this particular directions, the basically clear framework was provided to the banks and financial institutions and for taking timely actions and against the fraudulent borrowers and also fraudulent employees. So these particular directions are also for the inside the bank and also the outsiders of the bank. Wherever there is a fraud, these master directions are applicable, and also to disseminating the information to banks regarding such frauds. So coming to the basic purpose, as I said, for the purpose of the when this RBI issued this circular, because there are two different things. One is the circular on willful defaulters, and other is the directions on fraud. So now we actually are more of the time that we will spend today is the circular on willful defaults. So the purpose, as I said, the purpose of this circular is one, disseminating credit information about the willful defaulters, so that the other banks and financial institutions are cautioned. Also to reprimanding, to penalizing these willful defaulters, and that penalizing means their list kind of would be published, and the RBI list will have their name, and the banks also will have the authority to publish their photographs. So all this is basically a kind of mentioned in the circular, and also whether the amount is significant or not. So in this case, the amount is basically 25 lakhs has been kept as the amount outstanding, and then only the case can be considered as willful. So one that when we go to the definition, it is actually covering the lenders. The lenders, in fact, is all kind of financial banks and financial institutions. See where the any amount is due, and basically it includes even the off-balance sheet items like such derivatives, guarantees, letter of credits. Then when we talk about the borrowers, it is applicable to all kind of units like individuals, juristic persons, and other any kind of business organizations or enterprises, whether incorporated or not. So this is where the applicability is. When we talk about the juristic persons, like any incorporated entity, then any of the persons who are responsible for the management of the affairs of those management enterprises, those business enterprises, they were also be considered as the definition of units. So they would also be declared as willful defaulter in case they are the responsible for the management of the affairs of the that business enterprise. Now, the definition of willful defaulters that we have seen in the circular is basically threefold. One, the defaulted in meeting its repayment obligations to the lenders. This is one, defaulting even when it has the capacity to honor the said obligations. Now, defaulting and coupled with the capacity, that's very, very important definition of willful default. There are cases where the default has taken place because of the change in the business scenario, because change in the market scenario, the project economics. So those are not willful defaulters. So only those are willful defaulters where they defaulted while they were having the capacity to honor their obligations. Now the second condition, these are all independent of all the three conditions. The second is that this business enterprise or the borrower has defaulted in meeting its payment or repayment obligations and has not utilized the finance from the lender for the specific purpose for which the finance was availed. Now, this is something which is called diversion of funds. In case I have taken working capital funds and I have diverted those working capital funds to purchase of capital asset, that is also a willful default, because while I was doing it, I was very clear that I have taken working capital loan and I am diverting to buy land and buy new projects. Now, this can be even diversion to the subsidiary companies, diversion within the same company to different businesses, diversion to the holding company, and diversion to the associate companies. So this is something which is diversion. That means that the loan was taken for a specific purpose. However, it is utilized for a different purpose. However, it has remained within that entity or within that subsidiary or holding company entity kind of thing. Now, the third is siphoning of the fund. When the borrower is not able to meet the repayment or payment obligations and has siphoned off the funds so that the funds have not been utilized in the business organization where it was borrowed. Now, the siphoning off is that can be to other entities and to other business units. So that is what, or even for personal purposes, buying properties in personal names, buying assets in other companies' names. So these are the three definitions of willful default. One, I am saying that the not paid and not repaid because and still has the capacity. And the second is the capacity was there, but it was used for other purposes. The third is there was a capacity, but it was siphoned off. This is what is the definition of willful default. And the diversion, when there are some examples that we can discuss on the diversions. what is the diversion of funds? As I already said, the working capital or short-term working finance used for long-term purposes. Then deployment of borrowed funds for the purpose of activities, creation of assets other than those assets which are required for this project, for which the loan was taken. Transferring borrowed funds to subsidiary group companies or other corporate entities. Routing the funds through any bank other than the lender bank and the other than the consortium bank. Investment in other companies or acquiring through equities or debt instrument. The shortfall in deployment of funds, like you see in case when the project was being taken up, when it was being appraised, there was a condition that the promoters will bring, say, 30% of the total requirement. So there was a shortfall in bringing their own capital. That is also kind of diversion of funds that also can be used as diversion fund. Now, when we call about siphoning of the funds, that means the borrowed funds are basically used for unrelated operations of the borrowers. Then diversion is like it is negatively impacting the health, and then like constituting the because this is something which is totally outside the entities where the business has been borrowed. Although I think the important part that we have seen, capacity to pay, diversion of funds, siphoning of funds, and the security. When somebody says that this person actually have sold the security which was maybe stocks, maybe debtors, or maybe even capital assets. If a borrower sells the security and without the knowledge of the lenders, that is also a willful default. That is also a willful default, although it will also be covered under fraud. Now, the essentials that we have to see is, one is that the minimum outstanding is 25 lakhs that has actually been declared by the Central Vigilance Commission, and then it will be something which also has to be based on the track record. So in case it is a one kind of transaction, then it cannot be colored as a willful default. It has to be a kind of regular behavior of the borrower. And the third part is, which is very, very important, it must be premeditated, purposeful, planned, and assessed. It should not be kind of a consequence of something which is happened naturally. So it should be a very, very kind of planned action. Then it actually will become willful default. So then, like, let us understand what are the penalties of being declared as willful defaulter. When I say what are the penalties, then we also have to see the first of all, the penalty is that the banks will prohibit from granting any other loan. Banks will not grant any other loan. Then any institutional finance will not be available to that person who is a willful defaulter, that entity who is a willful defaulter, or that person actually becomes part of a director or decision maker or part of the management of another entity. All those entities promoted by a willful defaulter will not be able to get any additional finance, institutional finance, or they will not be even able to access the capital market under the SEBI regulations. They would not be able to raise capital through issue of shares, issue of debentures, or issue of any other securities from in the SEBI. Then even the banks have also been authorized to publish the photographs of the willful defaulters, and that way impact the social status or the business credibility of a person. Then once the willful default is a kind of reported, then the bank also may report a fraud based on that RBI directions on fraud reporting. The banks also can report. So willful default, declaring a person, declaring an entity, declaring a borrower as a willful to default is a very big event. It actually impacts the civil rights of a person. It actually impacts the business rights of a person. And then the banks even can think about even changing the management. Once the borrower is declared as willful defaulter, the banks can also even change the management. In insolvency law, we have seen once a person or an entity is declared as willful defaulter, it is not possible for them to even participate in any resolution process under Section 29A, even in various other kind of tenders, various other government positions, various, like even if this willful defaulter cannot even become an insolvency professional. So for various such situations, a willful defaulter will have kind of a status of a blacklisting himself or blacklisting that person. So that also, like, kind of it is also an issue on the integrity of the financial system. So this is where the kind of the willful defaulter impact the status, the categorization of a person as a willful defaulter will impact his financial life, will affect his the civil life to a great extent. The RBI circular has also illustrated some of the measures which actually the banks should take so that they are able to identify the willful defaulters quickly, and the information is disseminated to the other financial institutions and the banks and public at large. These kind of reports are required to be submitted every month, and there are formats for submitting such reports. So this is what is the like the banks have been advised that there should be a meaningful scrutiny of quarterly progress reports submitted by the borrowers, operating statements, or balance sheets of the borrower. There should be a meaningful scrutiny of all this. Then the regular inspection of the borrower's assets are also recommended by RBI. Periodic scrutiny of the borrower's books of account and the no lien accounts maintained with other banks also should be seen. Periodic visits to the assisted units is also recommended. System of periodic stock audit is also recommended, and periodic comprehensive management audit of the credit function of the lender also. Like there was a Ministry of Finance a circular on like the agencies for special monitoring, ASM. Now presently, if a company has taken a loan of more than 250 crores, the banks have been guided by the Ministry of Finance that they should actually appoint the agencies for specialized monitoring. And there is a very large format where these agencies like us, we report to the banks like how the credit management is being done, how the credit function of that company is being handled. And there is a report of about 30 pages that we fill up and we give it to the banks after studying the books of account, security, terms and conditions of the loan account, and also various transactions. That is also something which is recommended by the Ministry of Finance as part of the monitoring, as part of the regular scrutiny. So, Ankit, when we say we have already discussed the penal measures that the bank can take, one, the bank immediately will restrict any other finance. Bank can also immediately start legal process for recovery. Bank can start even insolvency processes in case there is a default. The bank can even change the management. Bank has also been advised that in all their documents, in all their loan documents, there should be covenants prohibiting the induction of individuals listed as a willful defaulter. That is a covenant in the loan document that even if the loan has been taken today, even after that, the company will not be allowed to induct any person in the management who is a willful defaulter. That also has actually been therefore the borrowers must be persuaded that all these kind of people should be kept away from their entity. Then the banks have been advised by RBI. Banks have been advised by the RBI that there should be a transparent mechanism for identifying the willful defaulters and for finding information about them and for even finally declaring them as willful defaulters. There should be a transparent mechanism, and also that what kind of penal provisions are there, it should not be misused, it should be exercised discretionarily, and it should be exercised minimally. So it is not really a kind of merit that we bring more and more people as willful defaulter. But yes, in case somebody is a willful defaulter, should not be protected. The power that has been given to the banks, it should not be misused, and it is a discretionary power. Therefore, it comes with a very, very great responsibility. Then we are saying that when we say how to make an assessment that a person is a willful default. So that is something where the banks have been guided to evaluate their repayment performance and also performance of the companies, individual companies or overall group. So the group companies failing to honor guarantees provided for the willful default units are also considered willful defaulter. Like if company A has borrowed and the company B has given the guarantee, and there is a default of company A and the company B is not able to pay because the guarantee has been invoked. So the A and B both will be considered as willful defaulters. A and B both will be willful defaulters because if the guarantee agreement is kind of a co-extensive agreement, it is the lender's choice. The lender can go and proceed against A and B both. That means the borrower and guarantor both, or even the lender can choose only to proceed against the guarantor and not against the borrower, or even vice versa. So this is something which is defined in the section 128 of the Indian Contract Act 1872. So that's what the banks can do as a kind of when it comes to the group. So when it is a group scenario, so individual company and guarantor. But then if an individual company is only defaulting, then the other group companies would not be considered as a willful defaulter. That penalty would not be extended to the other group companies unless those companies are in fact indulged into fraudulent transactions along with the main borrowing company. So therefore, the other group companies would be safe. However, the guarantor companies would be considered as willful defaulters. Now, when we say the treatment of, so this is where we are trying to say even the RBI has also put a lot of responsibilities on the auditors, like the auditors of the borrowing entity. It is actually mentioned in this RBI circular that the banks should file a formal complaint against the auditors of the borrowing company if the falsification of the accounts is observed and the auditors are found negligent. The complaint has to be filed with the Institute of Chartered Accountants of India. Again, while the complaint is pending before Institute of Chartered Accountants of India, RBI has also guided that complaint must be even forwarded to RBI. RBI has a Department of Banking Supervision, and it should be even forwarded to the RBI and also to the Indian Banking Association for record keeping. So what happens is the Indian Banking Association can circulate the names of those CA firms or CA in case they are individuals to in case there are multiple complaints, then it can be forwarded to all the banks and it can also be placed on their website so that everyone is kind of aware of the defaulting auditors. So this is a greater responsibilities on the auditors, and also the RBI will share such information with the other financial regulators. Other financial regulators will include the SEBI as well as Ministry of Corporate Affairs and CAG, Controller of the Controller of and Auditor General, CAG. So all this, any chartered accountant who actually is not vigilant actually can be such kind of complaints, like the complaint to Institute of Chartered Accountant, RBI, IBA, Ministry of Corporate Affairs, and CAG. So 5 complaints will go against that chartered accountant who actually is not vigilant in doing the audit, and the bank filed the complaint because the auditor was found negligent. So when we say it is the auditor's duty to see whether there is a diversion of fund, and the loan agreement, the RBI said, should also have the appropriate clauses or covenants where the auditor's certificate is required, and that auditor's certificate for utilization of the funds it has to be submitted. And these are the requirements. Then the inspection has been guided by the RBI that the internal audit or inspections can be directed or can be recommended to the borrower. That also, then this then the banks and the financial institution, something which is very, very important. Banks and the financial institution, they are also having an obligation to submit a monthly report to credit information companies in India. So there was a separate act called Credit Information Companies Regulation Act 2005, and that was the in that particular act, the RBI has given as a kind of license to 4 companies to work as credit information companies in India. So one important company that we all know is CIBIL, Credit Information Bureau India Limited. That's one company which has taken, which has grown because of their own efforts and publicity. And the other is the CRIF High Mark Credit Information Services Private Limited, and the other is Equifax Credit Information Services Private Limited, and Experian Credit Information Company of India Private Limited. So the report, whenever a bank has to submit report, the bank is submitting report to all these 4 credit information companies. And this again, it is provided that these companies have started. These companies are actually very, very important, and wherever the willful defaulter is having an outstanding amount of 25 lakhs and above, and they are also supposed to report that the suit has been filed against them, or suit filed companies or non-suit filed company has to be reported separately. And so this is the data which is information on almost real-time basis, and this actually data actually is being used by most of the lenders on day-to-day basis. See, then comes to the major dispute. The major dispute which we have seen in the judicial orders from various high courts or Supreme Court is on account of the process mechanism for identification of willful defaulters. So when we say process mechanism, the RBI has mandated all the banks and financial institutions that first of all, the examination by committee. There should be a committee, and that committee should examine the borrowing company and its non-promoters and non-whole time directors. So non-promoters and non-whole time directors are categorized separately, and the promoter directors and whole time directors are categorized separately. So the examination, there has to be a committee for the purpose of examination of the conduct of the non-promoters and non-whole time directors. And then we will come to the promoters and whole time directors. So this particular committee, it would definitely look into something which is the committee must be headed by a kind of executive director of the banks or any equivalent, because see, in this RBI framework, each bank has kind of a designations, and then each bank's designation is comparable to each other. So the bank says that the equivalent, the executive director or equivalent, that is the requirement, along with 2 senior officials. That is the committee which actually will identify the willful defaulters out of non-promoters and non-whole-time directors. Then if the committee finds willful default, it issues a show cause notice to the concerned non-promoter and the non-whole-time directors, and then both parties are given an opportunity to submit their responses, and a personal hearing may be granted if deemed necessary by the committee. So the personal hearing, the word is very, very important. It may be granted. However, there are some judgments where it is said that the personal hearing must be granted, but there are many cases where the willful defaulter has actually been declared without personal hearing, and the courts have upheld that. Then once this examination by the committee, then there is another committee which is a review by another committee which is a bigger committee, which is a senior committee. So the superior committee. In this superior committee, and the order prepared by the earlier committee, which is the examination by the committee, and that committee, the matter will come to the review with the another committee, with the superior committee, and that superior committee would be headed by chairman or chairman come managing director, or the managing director or the CEO of the company, as whatever name it may be, along with the independent directors and non-executive directors, along with the independent directors or non-executive directors. So this committee will review, and then only the order will become final after the confirmation by the review committee, except in the cases where the identification committee does not declare a order. In case the identification committee is not declaring a person as a willful defaulter, then it will not go to review committee. It will only go to the review committee in case the declaration is as willful defaulter. Now, the definition of non-whole time director is also given, or the non-promoter director is also given, because see, they are saying that they generally should not consider will unless it is conclusively established that they were aware of the default or they consented to do it. And also it was apparent from the board meetings or board proceedings that they know, because it is accepted that the non-whole time directors or non-promoter directors, they are actually coming in the board meetings only, and if there is nothing brought to the board meetings, then it will not be considered as their default. It will not be considered as they have consented or they had the knowledge of it and they have never kind of ring the bell. So this is where the reporting, as I said, that the reporting has to be done to the RBI and this financial information companies. So in case of willful defaulters, the banks also, in most of the cases, they also report the criminal action, and that criminal action of willful defaulters is under section 403 and 415 of the Indian Penal Code. And then when it is a criminal action, then of course the kind of intent, premeditated, these conditions are very, very important. And it happened out of natural calamity is not something which will be considered as a, but then it happened circumstantially. But then, however, it has to be pre-planned when it comes to the criminal action. So therefore, what we are trying to say now is the one is the accuracy has to be assured regarding the information about the willful defaulters, and that accuracy also has to go to the credit information companies. The reviewing committee, the committees that we are trying to say where their job is to clearly identify the willful defaulters, they should also have the facts about the directors and cross-checking also from the registrar of companies. As a grantor, that we've already said that the grantor also can be held as willful defaulters if they are not able to pay. Then we come to the government undertakings. In the government undertaking, this circular says that the directors of the government companies would not be held as a willful defaulter. However, if a company is defaulting, then according to in that particular case, it should also be mentioned in bracket that after the name of the company that it is Government of India undertaking or it's a Government of Punjab undertaking. That should be mentioned in the list which is there in the RBI website. In the RBI website, even with the individuals, it is also important that the DIN number must be mentioned to avoid any kind of confusions regarding the similar names. So this is what is the this is what is the basic RBI circular. So Ankit, by now we can take some questions. In case there are questions, then we could go to the judgments, because there are various judgments also. You are mute.
So one question is that if a company is a willful defaulter, can all the directors, KMPs, and promoters be declared a willful defaulter as well?
Yes, very clear. If a company is a willful defaulter, then all the promoter directors and all the whole-time directors will also be considered as willful defaulters.
Independent directors
However,
will not come into
however,
this.
the non-whole-time directors and non-promoter directors, that actually will have to go through a separate process, and that will be headed by the managing director of the bank. That is a review committee.
Okay. Then whether willful defaulter list is available to public? If yes, which is the website or where can you get this list from? And what is the periodicity of preparation of such list by RBI?
The reporting to credit information companies is monthly. The credit information companies like CIBIL, Equifax, Krill, these are the companies where actually this best information would be available. However, RBI also releases the list of willful defaulters on a periodicity of 6 months. This is what is my belief, because they may even do it earlier, but the updated information will be available on CIBIL, which is a public can access to CIBIL.
So banks also declare willful defaulter list on their website. So if you Google willful defaulter list, you will get several lists from the bank's own systems also. And of course, CIBIL and these are very good sources of understanding if somebody is having is a willful defaulter. The public platforms are there. Then we have a question that if the corporate debtor is declared willful defaulter, then can IRP, can he take an interim finance, or can an applicant bank can give interim finance to CD after classifying them as willful defaulter? So I
Yes,
believe
RBI
that
has
yes, there is no
clarified.
problem. Yeah.
RBI has clarified that the interim finance, none of the earlier circular, like the prudential norms and the NPA norms would not be applicable to interim finance if a company is under IVC.
Then somebody's question that the CC anonymous question that our CC account got disturbed and we were unable to pay the interest. Later, bank reported our account as willful defaulter, which is challenged in court and also got an order in our favor. We cleared the bank loan. We cleared the bank loan through OTS. Later in CIBIL, our company name is reflecting in defaulter list after all the dues are cleared. Also, it has been more than 5 years. So basically, uh, in case there is a court order which requires the bank to remove the willful defaulter tag, I believe you will have to follow up with the bank and get it removed so that the bank reports the updated details to CIBIL, and then CIBIL will also update that yes, the willful defaulter status is not valid. Alternatively, you can raise a dispute in CIBIL and say, or rather attach the court order which removes the willful defaulter tag on you. So I think this is the possibility here.
Yes, RBI mandates the lenders that if the account is settled and after the settlement it has been paid fully, then they can remove their names from the willful defaulters list.
Then what is the treatment of willful defaulter companies under IBC? I don't think there is a problem. There is a distinguishment. It's all the same. There is no separate provision for willful defaulters other than the part that this can be a criteria for a 29A default. That's what
So 29A is only for the resolution applicant,
yeah.
whereas the corporate
That's
debtor.
how it can change the IBC process for somebody, nothing else. So in case, let's say there's an MSME and that MSME is exempt from all the other provisions of 29A, but if it's a willful defaulter, then they will not be eligible to become a PRA. This is what I understand.
Yes, yes.
Then can a lender be held liable for lending the money to willful defaulter? Yes, due diligence is not exercised if somebody is
Yes.
already tagged as a willful defaulter and somebody has lent to that
Definitely,
person.
the lender will be
Definitely, the
considered as
lender will
negligent.
be, yeah,
Lender may also be considered as conniving.
yeah. Then father of the partners of a partnership firm can they be declared willful defaulter? I don't think there is any law in the country which can allow fathers or sons to be also called willful defaulter in case one becomes a willful defaulter.
No.
Then if the money name of
Unless
defaulter
the
is,
father is a grunter.
yeah,
And the
that could
father
be
is
a
not able to
separate,
pay.
yeah.
Unless the father or son is a grunter and they are also not able to pay.
If the name of the defaulter is removed from the list, then what is the cooling off period for defaulter to
5
again
years.
get finance?
5 years.
5 years.
Like in case from the date the person is declared as default, the willful defaulter, the cooling off period is 5 years. After 5 years, then he can ask for removal of this tag.
Dinesh ji is asking when Central Investigation Agency ED or CBI comes in picture. When do they come in picture in case of willful defaulter? They will come into picture due to other reasons like CBI reporting by the bank that there is a fraud.
So
There
they
might be a
that
criminal complaint, an FIR, which allows the ED and CBI to take over the investigation. Only willful defaulter, will that also bring in the ED or CBI, or can that
no,
bring in?
just a willful defaulter is not a reason for investigating agencies to come in. For investigating agencies to come in, the bank can take a cognizance that this person is a willful defaulter, and the fraud, banking fraud, if it is considered as a banking fraud, then the directions of reporting fraud dated 1st July 2016 will actually be invoked by the banks, and then it will be reported to various investigating agencies. So in fact, I have a complete list of investigating agencies depending upon the amount of fraud that to which agency it will be reported. If the banking fraud is more than 50 crores, then it will be reported to CBI, Joint Director CBI. So in case of a lesser amount, then it will be reported to the state units of the CBI. And then for a further lower amount, it will be reported to the economic offense wing of the state police, and so on. So there are different uh, classification of the various kind of frauds. And then accordingly, the RBI has directed the banks to report it to a different investigating agency.
Yes. So is MSME covered under willful defaulter? Yes, an MSME can be held to be a willful defaulter. I don't think there's a barrier to that.
No.
There is a possibility of that happening. Then a question whether guarantor for fully secured loan be treated as willful defaulter. Why fully secured loans will be considered as NPAs? NPA is a different issue. NPA has nothing to do with secured loans or unsecured loans. However, if NPA happens, then the provisioning requirements under the prudential norms of RBI are different for secured loans and different for unsecured loans. But that does not have any effect on the willful defaulter part. If the loan is not being paid, or somebody is not paying that intentionally despite having funds, or despite, or maybe that has done something hanky panky, then that status can come in.
Yes.
So yep, that's it. Questions are taken care of.
So, like, I think we can even talk about various orders, judicial orders, judgments on this subject. So, the first one that I would like to touch would be the little older, but then this is a very important judgment of 8th of May 2019, and State Bank of India versus 𝐻𝐸 Developers, JAH, 𝐻𝐸 Developers Private Limited. And this judgment was given none other than Justice R.F. Nariman and Honorable Justice Vineet Saran. So the question of law which was framed in this case on the master circular of RBI on willful defaulters, when a person is declared to be a willful defaulter under the circulars of RBI, such person is entitled to be represented by a lawyer of its choice before such declaration is made. So finally, it was held in this case that this is not a kind of a court proceeding, and however, I would deliberate in slightly in a detailed manner. But the basic question was whether the willful defaulter was entitled to be represented by a lawyer when he is representing before the first committee or before the review committee. So that is where this question of law was framed. And the Supreme Court of India considered all the RBI circulars, and it was basically like observed by the Honorable Supreme Court that the contention the appellant was saying, the appellant means in this case the appellant was State Bank of India, because the other court, the High Court, in fact held that it was required, that he was entitled to have a lawyer of his own choice for representing him before the committee. So therefore, he was actually absolved from this willful defaulter tag. However, that the appellant, this the State Bank of India, in fact, filed an appeal before the Honorable Supreme Court, and it was the appellant, the State Bank of India, said that the right to legal representation is no part of the right of natural justice. Then it was also contended that it is only an in-house committee of the bank. It is an in-house committee of the bank. It is not a tribunal under the Article 136 of the Constitution of India. And the in-house committee is not vested with any judicial powers and judicial powers to decide, because there is no kind of list. There is no kind of legal dispute between the uh, first committee or the review committee and the borrower. That kind of legal dispute is not present. The list is not present. So therefore, it was the contended by the State Bank of India that the forum, which is basically before which that person is appearing, that forum is not vested with judicial powers, and there is no list between the parties, and therefore, like it is not a tribunal. And also it was represented by State Bank of India that this right to representation, uh, right of representation can be restricted, controlled, regulated by the statute, rules, regulations, and standing orders. However, there is nothing like this in such cases. Whereas the respondent, like the JAH developers, they were saying that the in-house committee of the bank is a tribunal under Article 136 of the Constitution of India, and they were also they were also saying that Section 30 of the Advocate Act, wherever the presentation of evidence is required, the person should be given a right of legal representation. And finally, the oral, see, like it was also finally the decision of the Supreme Court was that it cannot be possibly said that either in-house committee appointed under the revised circular dated 1st July 2015 is vested with the judicial power of the state, their powers being administrative powers to gather facts and then arrive at a result. It was not a judicial power. They were only trying to gather facts. Thus, no lawyer has a right under Section 30 of the Advocate Act to appear before the in-house committee so mentioned. The Honorable Supreme Court further said that the said committees are not persons legally authorized to take evidence by statute or subordinate legislations. On this score also, no lawyer would have any right under Section 30 of the Advocate Act to appear before the same. And also Article 19, Sub-Article 1 and Clause G of the Constitution of India says that it was attracted in the fact of the present case, as the moment a person is declared to be a willful defaulter, the impact on its fundamental rights to carry on business is direct and immediate, and give these drastic consequences. The circular being in public interest must be constituted reasonably. And then further, while concluding, some clarification was given by Honorable Supreme Court that the state's judicial power is the power to decide a list between the parties and gathering evidence and applying the law, as a result of which a binding decision is then reached. The in-house committee are not vested with any judicial power at all, their power being administrative powers, given the in-house committees to gather facts. It cannot be said that a circular in any manner vests the state's judicial power in such in-house committees. On this ground, therefore, the view of the High Court is not correct, and no lawyer has any right under Section 30 of the Advocates Act to appear the in-house committee so mentioned. The said committee are not persons legally authorized to take evidences, because there is no evidence in such case. However, the court also said in this case, that even oral hearing may not be insisted upon. Even oral hearing may not be insisted upon as a right on all the proceedings, because there are some kind of accused who are accused as a willful defaulter, and they are also insisting for the oral hearings. The Supreme Court has said in this case that according to the Supreme Court, even oral hearings cannot be insisted. So this is the overall judgment of the Honorable Supreme Court. So The second judgment, which is also very important, it is latest, it is on 27th of March 2023, again in the case of State Bank of India versus Rajesh Agarwal. And this is also from none else than the Chief Justice of India now, Justice Dhananjay Chandrachud, and Honorable Justice 𝐝𝐬𝐬𝐬𝐿𝐬 Kohli. Now, in this case, the basic issue was, but that was on the other circular of the RBI, that was on the circular of fraud. The directions to all the banks and financial institutions on reporting of fraud to investigating agencies or to declare an account as fraud account. So this is the basic, the issue which was raised in this particular order was whether the principle of natural justice should be read into the provisions of RBI fraud classification and reporting by commercial banks and selected financial institutions directions 2016, which was given on 1st July 2016 as fraud classification and reporting by commercial banks and selected financial institutions. So in this case, the Supreme Court, Honorable Supreme Court has said that there are many, there are civil appeals before the apex court are filed challenging the particular RBI fraud classification and reporting by commercial banks and selected financial institutions direction 2016. So there are many such appeals are being filed. The directions given by RBI was challenged by various high courts, primarily on the ground that no opportunity of being heard is envisaged to the borrowers before classifying their account as fraudulent account. So the High Court of Telangana has held that the principles of natural justice must be read into the provisions of the master direction. The decision has been assailed by the RBI and basically various appeals finally are filed with the Supreme Court of India, and this was a collective judgment on 27th of March 2023, and this also had a lot of impact, and in fact it granted a lot of relief to those people who have been accused as fraudulent borrower. So one part out of this judgment is that based on various forensic audits, the consortium of lenders in fact have been declaring the accounts as fraud, and without even providing the opportunity of hearing to the borrower or intimating the borrower. So there are many such aggrieved people where the accounts were fraudulently classified without their consultation. They moved to various high courts challenging the constitutionality of the master directions of the RBI, and that is where the Supreme Court finally is coming to the was coming to this kind of judgment. And finally, the decision of the appellant court was, although I'm not because of the constraint of time, I'm not considering the various contentions of the appellant or the contentions of the respondents. However, I'm saying finally it was held that the principle of natural justice are not applicable at the stage of reporting a criminal offense. Principles of natural justice are not applicable at the stage of reporting a criminal offense. The rule of odi alteram partem, that means right to be heard, applies to administrative action, and under the master direction on fraud, the process of forming an informed opinion is administrative in the nature. So therefore, right of being heard, process of forming an informed opinion, that is important. Action with civil consequences must adhere to the principle of natural justice, and therefore the clause 8.12 of the master directions imposes civil consequences for the borrowers, their promoters, and their directors. Although the procedure for declaring the willful default differs from that under master direction for frauds, applying harmonization of master directions on fraud with natural justice, it actually debars the borrower. It is akin to blacklisting from credit access. It is actually potentially leading to significant consequences of the borrower's operations. Such blacklisting has civil consequences. So therefore, the kind of also the right of hearing is not expressly excluded. The master circular is not saying that the there is no right, or there is no right. Therefore, the principles of natural justice can be read into it, and the timeline under clause 8.9.6 is wide enough to provide adequate opportunity of hearing to the borrower before classifying it as fraud, and therefore it was held that the reasoned order has to be issued by the bank while classifying the account as fraudulent. The principle of equality and non-arbitrariness, that is also required. The principles of natural justice demand that the borrower must be served a notice, given an opportunity to explain the findings in the forensic audit report, and to represent before the account is classified as fraud under the master directions on fraud. Then finally, this is something which is the RBI has very clearly says that the notice to the accused, an opportunity to explain, sharing the audit report findings, seeking a reply and clarification. That is very, very important. Then only the classification as fraud would be sustainable. Then only the classification as a fraud would be sustainable. Now coming to the latest judgment, which is 4th of March 2024, which is from Milind Patel versus Union Bank of India. It is from Bombay High Court by Justice B.P. Kulabawala and by Justice Soma Shekhar and Sundaresan. Now, in this case, again, the facts are only on the basically the principle of natural justice and the principles or the provisions of inspection of the relevant material. So in this particular case, rather, this particular Bombay High Court has gone a step ahead. In the case of willful defaulters, identification and classification of willful defaulters, the relevant material which is being relied by the lenders also should, the right should be given to the borrower for inspecting that relevant material. This actually has, this is a case of Milind Patel. This is a former managing director of IL and FS, and basically the order passed by the Union Bank of India declaring the firm and its promoters as willful defaulter, that was challenged, and in fact the petitioner also, like this Milind Patel, also received a kind of order from the review committee confirming his identification as willful defaulter. However, the petitioner was not served with a copy of the draft order. He was not given an opportunity to respond on the draft order. He was not given the relevant documents which are being relied by the bank while declaring him as the willful defaulter. All those documents which are used by the review committee was also not shared. So therefore, the finding and of the judgment was, the decision of the court was, the Union Bank is permitted to withdraw the final order passed by the review committee as well as the draft order purportedly passed by the identification committee in relation to the petitioner. The Union Bank is given the liberty to provide all material underlying the show cause notice relevant to determining the petitioner's role in the alleged willful default. The petitioner is granted liberty to provide a reply to show cause notice after reviewing the material disclosed by the Union Bank. The identification committee of the Union Bank must consider the petitioner's fresh reply and submissions made after reviewing the relevant material and dealing with the show cause notice. The banks and financial institutions invoking master circular to declare willful defaulters must identify the members of the identification committee and the review committee, and they share the aforesaid orders passed by such committees. Any agency that has published or disseminated the petitioner's name as a willful defaulter based on the now withdrawn orders from the Union Bank of India must remove such identification and have this. So this is the very, very recent judgment, so giving some relief to willful defaulters or the accused for willful default. So this will actually give a lot of kind of relief to them. Similarly, there are judgments in the name of Dumpala Madhusudana Reddy versus REC. And I believe this is from Telangana High Court. It has been given by Justice Alok Aradi and Justice Anil Kumar Jukanti. I believe this is again in the case of Lanco Group. And again, the similar things like again, it was in the case of Ind Bharat Power Limited. And this was various, again, the committees and the appellant have not been informed about the constitution, not informed about the constitution of the review committee. The member's name was not disclosed, the material was not shown. Another judgment is in the name of Jagdish Prasad Sabu versus IDBI Bank, and this is from Gujarat High Court, and this judgment is 6th November 2023. 6th November 2023. It is from the Chief Justice of Gujarat High Court, Justice Sunita Agarwal, and Justice Aniruddha P. Mai. This is again on the similar issues. It is in the case of the director of Surya Exim, whose account has actually been termed as NPA. So again, it's a willful default case. The court, in fact, has held in this case the again due to the because this was basically a case which is slightly different. In this case, the appellant was arguing that since Section 95 proceedings under IBC has started, so therefore there should be a moratorium on the proceedings of declaring him as a willful defaulter. Section 95, the personal insolvency of the personal guarantors. So that application was already initiated. So therefore, he was claiming moratorium. But finally, the High Court has held that there is no moratorium on the proceedings where he would be held as either a fraud or as a willful defaulter. So that's all. Like, I think I also have a very, very recent judgment, which is in the case of Ratul Puri versus Punjab National Bank. And this judgment is dated 29th of February 2024. And it is from Delhi High Court. And this has been given by Justice Purushendra Kumar Kaurav, and it is again the same, the review committee and the assessment committee. So the decision of the High Court was whether there were basic issues, whether the observation made in the forensic audit report can be sole basis for the bank to conclude the event of willful default. The High Court has said that the forensic audit report can only be considered as a fact-finding agency. They cannot conclude. They cannot be conclusive. It has to be corroborated by the bank with other evidences. Then only it will become willful default. The second question in this case was, the identification of willful default has to be made keeping in view the track record of the borrower and not on the basis of isolated transactions or incidents. And the Honorable High Court has said, yes, it cannot be on the isolated transactions. It has to be in view of the track record of the borrower. Then, like the mere fact that an earlier corporate debt restructuring scheme was finalized and nothing negative was flagged at that stage may not come in way of the lender bank in invoking jurisdiction under the master circular. Yes, the CDR scheme was different and this particular circular is different, so that may not be. So finally, it was concluded that the reasons assigned in the impugned order passed by the review committee confirming the petitioner as willful defaulter under the master circular are unsustainable, and the impugned order is accordingly quashed and set aside. So therefore, the petition was allowed. So this is all, Ankit, from our side. We have actually seen the latest judgments from Gujarat High Court, Delhi High Court, Telangana High Court, and the latest judgment from Supreme Court. And this is all about the present scenario in the country on the willful default status. Any question that we have, we can still take and spend about 2-3 minutes more. You're mute.
The question that says that some borrowers have been insisting for supplying all the documents which are shared with the forensic and transaction auditor. This is very difficult as the sharing of information of documents with auditors is a continuous exercise and no such inventory of record is kept. How to deal with such request?
So what is held by the Honorable Delhi High Court is that the report of the forensic auditor can best be considered as a fact finding, and those facts has to be corroborated with the evidences and the documents. Then the Supreme Court also says that the accused must have the access to the relevant documents which are being used for assessing him as the willful defaulter. So therefore, the all these documents, in case we share, that actually will make the case more stronger.
So, Mr. Rajesh Goel is asking for the Supreme Court judgment to be shared, the name again. He wants the name to be maybe shared again so that he can
Now, the
look it
Supreme
up.
Court, there are two Supreme Court judgments. One that I said it is in the case of JAR developers. JAR developers is the judgment, and which is the State Bank of India versus JAR developer, and the second judgment is which is the State Bank of India versus Rajesh Agarwal, and that is dated 27th of March 2023 from CJI.
Right.
Judgment of Supreme Court of India.
Then there's a question that in case MSME has taken a loan under the CGT MSC scheme, can he be declared a willful defaulter? So yes,
Any kind of loan,
yeah,
any
doesn't
kind of
matter.
loan. There is nothing in the law.
Another question which says forensic audit, is it mandatory before declaring someone as willful defaulter?
See, the RBI circular on reporting fraud definitely says that the forensic audit should be there, but the High Court says that the forensic audit is only a fact finding. So when we see when there are conclusive evidences of fraud, and the bank can also make an assessment of the fraud, and there are documents which actually can immediately say that there is a fraud, I don't think the forensic audit is a must for this. Only the relevant document is must.
Right. All right. I think we're done with the question.
So thank you very much. We get motivated and again work hard on this. So I think the next time we are coming with a subject which is actually in most of the demand in most of the real estate cases. We are trying to research on this subject. What is the reverse insolvency? How many cases so far has actually been passed under the reverse insolvency? Whether the cases have been resolved or not? What are the conditions under the reverse insolvency? So this is what we are studying, and while we are studying, we are also learning. So that is the reason that we say this is our way of learning. Thank you very much.
Thank you, everyone. Thank you so much.